US shoots down Chinese spy balloon. Who in the world would have the expertise to know whether that's legal or not?
Everyone asks what the Chinese balloon is doing, but no one asks how the Chinese balloon is doing. Well, the answer is poorly. It was shot down. At last, our long national nightmare is over. The Chinese balloon that terrorized American citizens from Alaska to South Carolina is no more. The United States can now begin the arduous process of reconstruction and, perhaps, reconciliation. Look, was the United States legally allowed to shoot down that Chinese balloon or not? And if so, on what legal basis? That's all we're here for today. As a former artillery officer, joint terminal attack controller, and lawyer in the US Marine Corps, and current civilian prosecutor, I have the authority and contractual obligation to opine on the internet about all things vaguely military and law. Sorry, those credentials plus my gigantic ego speak for themselves. So let's dig in to Balloongate. On January 28th, a balloon originating in the People's Republic of China entered the American Air Defense Identification Zone north of the Aleutian Islands. It proceeded to drift at about 60,000 feet elevation over Alaska, Western Canada, and then through the contiguous United States from northern Idaho to South Carolina. Once the balloon had started drifting over the Atlantic Ocean, a U.S. Air Force F-22 shot it down. In a statement, Secretary of Defense Lloyd Austin, who absolutely can still rep 315 natty on the bench press, described the balloon as a high-altitude surveillance balloon, which was being used by the PRC in an attempt to surveil strategic sites in the continental United States. President Biden then gave authorization to take down the balloon as soon as the mission could be accomplished without undue risk to American lives under the balloon's path. Ultimately, the DoD decided to attack that dastardly balloon over U.S. territorial waters off the coast of South Carolina. On February 4th, about 6 miles from the coast, a U.S. Air Force F-22 engaged the balloon with an air-to-air missile and took it down, pushing out just slightly our subjugation by our balloon overlords. U.S. Navy and Coast Guard vessels were in the area to take custody of the remains. China, meanwhile, expressed strong discontent and protest against the use of force to attack an alleged civilian unmanned aircraft, whose presence on U.S. territory was totally accidental. The Chinese Foreign Ministry went on to say, in these circumstances, for the United States to insist on using armed force is clearly an excessive reaction that seriously violates international convention. China will resolutely defend the legitimate rights and interests of the enterprise involved and retains the right to respond further. Now, strong discontent and protest. That's like the diplomatic equivalent of giving another country a 1-star Yelp review. But the end of that statement is kind of interesting. Was this a serious violation of international convention? And does that mean it's a violation of international law? And what does that mean? Studying international law is a little bit like studying how preschoolers play games on the playground. Some game rules are explicit and probably even written down somewhere. Some rules are just kind of understood and can change a little bit over time. And then there are plenty of situations where there are no rules. And honestly, if you even ask the kids what the rules are, they probably won't consistently explain them. Also, some of the kids have nukes, so that changes things too. In international law, one of the key foundational concepts is sovereignty. States are sovereign. For most of history, states had the absolute and inviolable right to decide what happens within their own borders. Now, the 20th century saw some attempts to limit the concept of sovereignty, for example, in genocide. But it is still a fundamental principle of international law. In fact, Article 2 of the UN Charter states that the United Nations is based on the principle of the sovereign equality of all its members. Now, sovereign states have borders. Those borders can follow land features like mountains or canyons, or water features like rivers and oceans, or can just cut right through a farmer's field based on an agreement and probably some bloody wars in the past. Whatever makes up the borders, states have complete sovereignty over the airspace above their territory. No foreign aircraft may fly into a state's airspace without the permission of that state, which may be granted by either ad hoc decisions by the state or by general or bilateral international agreements. So here's a question. What's the vertical limit of airspace? I mean, it can't go on forever. And the short answer is there is no international agreement that fixes the vertical limit. I mean, there have been some attempts to set it at something called the Kármán line, which sits about 100 kilometers or 62 miles above mean sea level, but there's nothing definitive. There's no one agreement. A really easy, quick rule of thumb is this. If it's in orbit, it's in space, not airspace. For our purposes, let's just agree that the balloon at 60,000 feet above mean sea level is well within the United States' sovereign airspace. Coastal states like the United States have some additional airspace as well. A coastal state can claim water out to 12 nautical miles from the low tide line as the state's territorial sea. Now, there are also things called the contiguous zone and the exclusive economic zone, but we just don't need to talk about them. In the territorial sea, a country has exclusive sovereign jurisdiction. Those waters belong to the state just as much as their land. And so, by extension, coastal states have complete sovereignty over the airspace over their territorial seas. So, all well and good so far. But how do we get to the world we actually live in, with people and cargo flying between sovereign states every day? I mean, obviously, they're not just violating each other's sovereign airspace. Well, when it comes to relations between sovereign states, the traditional view is that a state is only bound by rules it consents to. So, the primary source of international law is the treaty. Two sovereign states consent to a treaty. Once they consent, they are bound. Violation of that treaty can come with consequences. According to the US Constitution, a duly signed and ratified treaty has the force of federal law. And before I see it in the comments, we don't have the time to talk about the difference between self-executing and non-self-executing treaties. We're not doing that. We're also not talking about customary international law, maybe some other time, preferably never. The primary treaty dealing with air traffic is the Convention on International Civil Aviation, which went into effect in 1947, and is also known as the Chicago Convention. The Chicago Convention has been ratified by every single member country of the United Nations, with the exception of notorious rogue state Liechtenstein. That means the US and China are bound to follow it. The Chicago Convention goes into detail about how states should deal with a number of different situations involving civil aviation. In addition to establishing the rights and obligations of member countries, the Chicago Convention established an agency within the UN called the International Civil Aviation Organization, or ICAO. ICAO exists to develop and adopt standards and recommended practices. Member states are required to keep their internal standards and practices as uniform as possible. Article 1 of the Chicago Convention acknowledges what we already know. Every state has complete and exclusive sovereignty over airspace above its territory. Article 3 goes on to say, every state must refrain from resorting to the use of weapons against civil aircraft in flight. Now, this is important. It is generally understood that a use of force against a foreign registered civil aircraft is assimilated to a use of force against the state of registration, and therefore a breach of Article 2, Sub 4 of the UN Charter and associated customary international law. Let me say that again more simply. Shooting down a foreign civil aircraft can be seen as an act of war.
Thanks, Captain Obvious.
The Chicago Convention also very helpfully talks about unmanned free balloons, because, folks, this ain't the first time a balloon has floated over a foreign state. Annex 2 to the Chicago Convention is called Rules of the Air, and Appendix 4 to Annex 2 specifically talks about the rules governing unmanned free balloons. Now here, just to be clear, a free balloon, it's not like Free Willy, it's just a balloon that doesn't have any tethers. So here are the pertinent rules. Paragraph 2.2. An unmanned free balloon, other than a light balloon used exclusively for meteorological purposes and operated in the manner prescribed by the appropriate authority, shall not be operated across the territory of another state without appropriate authorization from the other state concerned. Paragraph 2.3. The authorization referred to in 2.2 shall be obtained prior to the launching of the balloon if there is reasonable expectation when planning the operation that the balloon may drift into airspace over the territory of another state. So now we understand why the Chinese Foreign Ministry phrased their objections the way they did. Remember, they said, in these circumstances, for the United States to insist on using armed force is clearly an excessive reaction that seriously violates international convention. China will resolutely defend the legitimate rights and interests of the enterprise involved and retains the right to respond further. So first, the Chinese statement talks about the legitimate rights and interests of the enterprise involved. That's a clue. That's the first indication that they're relying on the Chicago Convention, because it implies that the balloon was a civil aircraft rather than governmental or military in nature. More importantly, by describing the balloon as a civil aircraft, as I said before, the Chinese Foreign Ministry is saying that the use of force against the balloon is equivalent to the use of force against China itself. Second, the Chinese Foreign Ministry claims that the balloon was just a weather balloon. If that's true, per paragraph 2.2, it is an international standard that you can fly a light balloon exclusively used for meteorological purposes over another country without that other country's authorization. Now, one problem for the Chinese is that a light balloon has to have a payload weighing less than 4 kilograms or about 8.8 pounds. Just eyeballing that Chinese balloon, the payload looks pretty big. And according to one news source, the payload was the size of 2 or 3 school buses. So unless those buses are made out of paper, payload almost certainly weighs more than 4 kilos. And therefore, the authorization exception in paragraph 2.2 wouldn't apply. The other problem for the Chinese Foreign Ministry really boils down to messaging. Right before the shootdown happened, a spokesperson acknowledged that the balloon was Chinese in origin and described it as a civilian airship used for research, mainly meteorological purposes. Well, that's not the standard for paragraph 2.2 of the Chicago Convention. The standard is exclusively for meteorological purposes, not mainly meteorological purposes. Oops. Third, the Chinese Foreign Ministry stated that the balloon was affected by the westerlies and had limited self-steering capability, so it deviated far from its planned course. Now, this statement is designed to deal with paragraph 2.3. Remember, that paragraph says it's an international standard that you need to obtain authorization for overflight if there's a reasonable expectation that the balloon may drift into the airspace of another country. Basically, China's saying that there was no reasonable expectation at the planning stage that the balloon might drift into US airspace, so no US authorization was required. This is a better argument for the Chinese, but we would require a lot more information about the supposed planned purpose of the balloon to really evaluate it. While the Chinese government tried to shoehorn the balloon into the legal framework of the Chicago Convention, the US government rejected that approach entirely. By claiming the balloon is military or intelligence in nature, the US is implicitly saying that the Chicago Convention does not apply at all. Instead, we're operating under the more fundamental framework of sovereignty. The United States has exclusive sovereignty over its airspace. The US has consented to a certain framework for foreign civil aircraft to operate within its airspace, but the US has never consented and does not consent to Chinese surveillance balloons in its airspace. But hey, didn't we used to do surveillance missions over like Russia and they got to do the same thing with us? Yes! In fact, 35 separate countries in NATO and the Warsaw Pact signed the Treaty on Open Skies in 1992, which specifically allowed for unarmed aerial surveillance flights over one another's territories. The problem is, one, that never included China, and two, President Trump withdrew the US from that treaty in 2020. More importantly, that was a treaty. The US consented to it. The US did not consent to the Chinese surveillance balloon. So is there some special legal basis for shooting down that balloon? Honestly, not really. Insofar as it was a surveillance balloon and it violated the US's sovereign airspace, it was a legitimate target, just as if it were a fighter jet. It is worth pointing out that the US never argued that the balloon was somehow a threat. The Department of Defense made it clear that the balloon did not pose a military or physical threat. So this isn't about self-defense and the law of armed conflict. There's no invocation of Article 51 of the UN Charter, which says, "Nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations." The US's position is purely about sovereignty. The thing about sovereignty, of course, is that while it is absolutely a thing, it is always balanced by the realities of domestic and international politics. Just because the US could shoot down the balloon doesn't mean it has to shoot down the balloon. And just the same, if China really does feel like this is a violation of the Chicago Convention and a use of force against China itself, China has the choice of whether to respond appropriately or just kind of let it slide. That's politics. All in all, this is just yet another touchy affair between the US and China, one that could fizzle out entirely, or one that could be another rung on the escalation ladder to armed conflict. Only time will tell. Speaking of armed conflict, though, apparently after the balloon was sighted in Montana, some great American heroes were on social media promising to shoot it down themselves, unsurprisingly putting patriotic fervor ahead of basic physics. The York County Sheriff's Office in South Carolina gave the appropriate legal advice on Twitter, which we also adopt here on LegalEagle. Don't try and shoot it. Your rifle rounds will not reach it. Be responsible. What goes up will come down, including your bullets. Indeed.
I guess that's one thing that firing a gun randomly in the air won't actually solve. I guess there's a first time for everything. And on top of that, China has just admitted that there is another balloon over Latin America. Now that doesn't involve US law, so we won't be covering it here, but you will be able to keep tabs on it with today's sponsor, Morning Brew, because that's my favorite way to catch up with pop culture and the news. In fact, they already covered balloon number 1. When I wake up, Morning Brew is the first thing that I read. I've actually been subscribed to Morning Brew for forever. It's one of my absolute favorite newsletters, and I'm thrilled to tell you why. Because Morning Brew, if you didn't already know, is a free daily newsletter delivered Monday through Sunday. It gets you up to speed on business, finance, tech, and the law in just 5 minutes. And it provides a fantastic quick summary of the most important issues while being witty, irreverent, and informative. I often literally laugh out loud. And did I mention it's completely free? This week I learned all about Beyonce making Grammy history, the record US job numbers, and the Indian billionaire who lost $108 billion overnight. It's basically exactly the mix of news that I'm actually interested in and the stuff that I didn't even know that I wanted to know about. And it's all written in a hilarious style. Morning Brew is one of the few emails that I actually open every single day. So Legal Eagles, this one is a complete no-brainer. Morning Brew is completely free and it just takes 15 seconds to subscribe. Just click on the link that's on screen right now or down in the description to get Morning Brew for free. And not only will you get a newsletter that you'll actually read, you'll actually help out this channel too. So click on the link below to get Morning Brew right away. And after you sign up, click on this playlist over here for more Legal Eagle, or I'll see you in court.